GDPR gives every user the rights, different kinds, to see what is all about his information. In the last 10 days, we have discussed in detail each of those rights. But apart from that, there could be reasons where the data controller and the data processor decide that the right could be rejected. In this video, we are going to talk about situations in which the data controller and processor can reject any right accessed by the user. Welcome to my YouTube channel where you have been regularly watching new content on data privacy. Let's quickly touch base on what the user rights. They are like right to information, to know what information is there with the data processor. You can access that information, you can get it rectified if you think they are carrying wrong information. You can request them to erase the information altogether or just restrict the processing for the time being. You may resume processing later on. Maybe you get information, you get restricted processing at that point in time. Use the right to rectification and rectify the issues that you see in your information, and then you resume the processing, right? So you can use them in sequence, in multiple sequences. You do have right to data portability, where you can ask them to give your data back to you in a common machine readable format so that you can share it with some other processor. The user can object that he does not like the way his information is being processed, and he can also put in a request that automated decision making is not allowed for his information. So these are the various user rights that are there. You can go into the details of each of them in the various videos on my channel. Now, what are the situations in which GDPR allows the processor and the controller, they can reject a request to these rights, any one of them or specific situations? One common thing that anyone would be understanding, it's a very reasonable thing to say that if there is any legal basis, that means there is any litigation going on, some public litigation is there on any particular piece of information or any particular process, and your information is a part of that process, the right to erasure would not be allowed until a decision has come in from the law regarding that particular case. So in that case, there is no point erasing any individual's information, because that can impact the public interest as well as legal litigations on it. Even if there are some legal claims that someone has made on you or on a system or an organization, and your personal information is a part of that litigation on the legal claim, which is a commercial claim, even then the controller and the processor can get back to you and say, sorry, we cannot erase. Even we cannot now even amend your information, because it's already submitted to the court of law with the information that was available at the time of the litigation started. Slightly simpler ones, the processor conducts a data protection impact assessments and finds that the personal information is important and cannot be rectified or cannot be stopped processing or cannot be erased, so he can inform you back. Accordingly, it could be a matter of public security or national defense, due to which the controller and processor can reject your request for any of your rights that you want to access on your personal information. If the restriction that you want or the right that you want to use impacts the freedom of expression information. For example, there is a journalistic academic interest, and you say that I want to get my information erased, then that can be rejected. The right to access, rectification, erasure, any of these being used there and impacting the freedom of expression, impacting press and media, they can get your right rejected, and your information could continue to be processed the way it has been processed. If your information is being used for a public health issue, some public health, some disease, some research issue, then your right to access or rectify or erasure morally also needs to be rejected, because your personal information in this case, of course until it is being misused, but your personal information can help save lives. So why not let your personal information be used to conduct those medical researches at least? If your personal information has been archived from some statistical purposes, for some historical research, etc., again, then the controller or the processor can reject your request. If you are making too many requests and they are getting often unrejected, or if you are getting too many rectifications done to your personal information too frequently, then again controller and processor can reject your request. And if your information, and we discussed this when discussing the individual rights also, that if your information is already coupled with anyone else's information, and the other person does not give the consent to share their information in terms of right to information or right to access kind of thing, then again your rights can be rejected. Now, while all these rights can be rejected, you still are allowed to go to the senior authorities within the processor's organization, or you can go to the judiciary to discuss and express your concern why you want your right to be taken care of, and pending whatever gets decided in the arguments is what can be done. But these are the ways in some situations where you cannot access your right, as the data or the information that is being processed is critical for either healthcare or litigations or in general public interest. That is what I have on the restrictions to the user rights that GDPR allows to put. I hope you like my content. If so, please press the like and bell icon. Subscribe to my YouTube channel to get regular data privacy updates, and share your feedback in the comment section. Thank you.